Ready, start. Even assuming that the appellant wife had attempted to commit suicide on 6/11/2005, what prevented the respondent husband from informing the same to the police when he had stated in his affidavit that the incident which took place on 6/11/2005 is not first of its kind and that the appellant wife had attempted to commit suicide on earlier occasions. Also, and that the said attempts were thwarted by him. He could have informed the police about her suicide attempt, which can easily be corroborated by the evidence of his family members, driver, and neighbors. Moreover, the said incident had occurred after 7 years from the date of marriage. So, this court cannot assume that fearing police case under Dowry Prohibition Act, the respondent husband has concealed her suicide attempt. Had the appellant wife really jumped from the balcony with an intention to commit suicide, which is stated was witnessed by the husband, children, and driver, definitely the same could have been reported to the police. It is only Pranav, the elder son, who has in his evidence stated that his mother slipped and fell from the balcony. The evidence of the child CW1 is in support of the mother, but the fact remains that both the children are now living with their father and are not willing to go with their mother. The evidence of the son can be accepted as he is accepted to be the eyewitnesses. Hence, this court is not inclined to disbelieve the evidence of Pranav. Misunderstandings are part and parcel of marital life. If there is no difference of opinion between the husband and the wife, then it is certainly a news. Though in the case on hand, the respondent husband has stated that his refusal to lend money to the parents of the appellant wife frustrated her to commit suicide on 6/11/2005. The same ought not to have been accepted by the court below. From the pleadings, it is seen that after the alleged incident, the respondent husband had taken care of the appellant wife for nearly 2 years and thereafter, on account of his leaving to Rajasthan, since there was no one to look after her, the appellant's wife had to move to her mother's house, which cannot be termed as desertion. If really there was a difference of opinion between the appellant and the respondent, and there was an attempt to suicide by the appellant, the respondent would have given such information to the police, and there is no reason for him to take care of her for more than 2 years. It may be true that the wife has not filed a petition for restitution of conjugal rights immediately, probably believing that the husband may join her. The very fact that he had appointed a servant maid to take care of her shows his humanitarian attitude, even assuming for the sake of argument that in order to avoid a police case, he has not disclosed that the appellant's wife has attempted to commit suicide. No prudent man will remain quiet if it was a second attempt. There is no proof of repeated attempts of suicide as alleged.